We're obviously all a little bit further away from each other than we have been in the past. It's a little hard to all be isolated, not together in shul. Hopefully soon, with God's help and with the help of lots of great science, we will be together quickly. But as part of the kind of isolation that we're in, I've felt that one of the main goals is really to retain our sense of community. There's lots of Torah learning out there on the web. There are hundreds and thousands of archived classes. You can learn anything you want on YU Torah and myriad other websites. So our goal with a lot of our Zoom has not just been learning, certainly is learning, but it's also to, I think, link us together as a community. And as part of that, we launched something called the Voices of Kesher series. One of the great blessings of Kesher Israel is that we are a shul that is really chock full with incredible folks who are extremely talented in their areas, have a very wide sense of learning, both Jewishly and in secular thought, and it's this is a city of and a shul of really strong intellectuals, and sometimes just because a person could be traveling the country and speaking all the time to large audiences, but when they're your congregant, okay, so you're used to just kind of seeing them in the second row there and they daven, and we don't always think about the gold that is hidden right under us, as the Midrash says. And so I really saw this, and I want to say a big thank you also to Lily and to others who have been working on Zoom and getting this all together. This has really, we are seeing this as an opportunity also to highlight our very own. There are so many that have davened in the shul for so long, and we don't always hear from them. And they really have a great deal of wisdom to share, both Jewishly and about the general world. And that's one of the great brachas of Kesher Israel, is that it really is a crossroads and a place and a shul that truly brings together, I think, the ideals of modern Orthodoxy, of deep and serious Jewish commitment and Jewish learning, but also really high level secular learning and study. And because it's Washington, it's also a place of application of thought to the real world. And so we're going to have a bunch of folks. By no means is our Voices of Kesher that we have planned so far, which is 3 more lectures, going to exhaust all the talent in the shul. There's lots of it, and I hope that we'll keep this going. Maybe this is a good thing we should keep doing. Hopefully, even, please God, after we're together soon. But I hope that we'll continue to highlight lots of the great teachers in our shul. So I want to say a tremendous thank you to Rabkin, who lots of you probably know. He's there at davening every Shabbos, very much early, and you can see him there in the second row in the middle. But he also is an extremely accomplished professor of law. He is a professor of law at George Mason University, where he teaches, among other things, U.S. constitutional history, administrative law, and international law. He was appointed to the board of directors of the U.S. Institute of Peace by President George W. Bush and reappointed by President Barack Obama. Before coming to Washington in 2007, he taught in the Department of Government at Cornell University for more than 2 decades. We are thrilled to have him with us. Welcome.
Thank you. The first chief rabbi of Israel, Yitzhak Halevi Herzog, who was previously the chief rabbi of the British Mandate in Palestine. But before that, he was the chief rabbi of Ireland. And I mention him because he published this book in the 1930s, I think just before he came to Palestine. He must have finished it anyway before he came to Palestine. In English, Main Institutions of Jewish Law. If you're really interested in comparisons, that's the book to go to. He was just immensely learned, and he discusses details of contract law, property law, tort law, and he gives you what it is in Roman law, what it is in English common law, and you just think, wow, people used to be real scholars. I mentioned him at the outset because that's not me. I'm not able to do that, and I don't propose to do that. I want to do something much more modest, which is give you just a little bit of perspective, and let's say comparative perspective, on the situation that we're in right now, coping with this pandemic. In mid-April, you may recall this, President Trump said, "The President of the United States calls the shots. State governors cannot do anything without the approval of the President of the United States. When somebody is the President of the United States, the authority is total." He just said that. I don't know why he said that. I don't believe his White House counsel told him that. I don't believe his White House counsel would appear in public and affirm that. I don't believe his Justice Department would say that. I'll just invoke one quick anecdote, which is we had a few months ago a workshop at George Mason, and we had people from different government departments. And this came up, how do you treat tweets from the president? Do you regard them as authority? And somebody from the Justice Department said, "We looked into this and we made a determination, no, he's just talking. That's not a directive." And the reason this was a memorable experience was that someone from the Transportation Department said, "Yeah, we looked into that. That was our view too." And all around the table, people said, "Yeah, that's what it is. He's just talking. That's not." Okay, so let's put that aside. No Supreme Court decision, I think, endorses anything close to that. It's just not right. But if you ask what kind of authority does the president have, the truth is, it's really not very clear. He has some authority from statute. In fact, he has a lot of authority from statute. But it's not clear that it's very directly relevant to what's happening now. The Brennan Center at the NYU Law School put out a paper which is quite interesting. They tried to count every authorization to the president of emergency powers, and they came up with 136 statutes. The reason that's interesting is if you have 136, it means you don't, at least as Congress doesn't seem to think, there's one general grant of emergency power that will do it. It's a whole bunch of very specialized things. He can adjust the tariff schedule. He can withhold payments to federal employees. He can give extra grants to the states and so on through a lot of specialized things. The Congress is not willing to say, if there's a general emergency, it's up to you, do whatever you want. Almost everything controversial, in fact, that's happened in the last, whatever it is now, 2 months, 3 months, has come from governors. And the governors pretty much are acting on their own. We are now in the process of relaxing these controls at the state and local level. The White House has put out guidance. The governors don't seem to feel bound by that. President Trump doesn't seem to think really it's important that they follow it. So governors are on their own. But then you have the question, okay, where do the governors get this power? I'm particularly focused on the kind of general lockdowns that we've had. Governor Hogan, next door in Maryland, issued a proclamation on March 16th, which he shut down restaurants, bars, fitness centers, theaters, a whole series of things. And he said, this is, I'm doing this on authority vested in me by the Constitution and laws of Maryland, including but not limited to Title 14 of the Public Safety Act. So I went and looked this up. Public Safety Act, Title 14, deals with emergencies that result from fire, flood, riot, weather, or other cause. And it allows the governor to proclaim a day for the general cessation of business. There is a provision on health powers. which allows the governor to order vaccination, quarantine of individual persons in particular categories. There's nothing in the Maryland Code that is anything like what Governor Hogan ordered. I'm not saying this to condemn him, but just to put this in focus for you. He's done something like quite remarkable, which is why he or his lawyers thought to say at the outset, this doesn't really rely on the Maryland Code. I just have this power as governor. Right? And so I just want to focus you on, like, really, you have this power? What is that power exactly? I should say Mayor Bowser has done a little better, and I think it's because Governor Hogan can't so easily go to the Maryland legislature and say, do this. Whereas Mayor Bowser has had more success going to the city council and saying, I need new authorizations. But it is actually, of course, not surprising. If you look at what was in the code of the District of Columbia, there was nothing that really addressed what if there's an epidemic and you need to close down everything. We just hadn't been thinking that way before this spring, right? We didn't do that back in 1918, and so we didn't provide for it. And if you're not in the fortunate position of Mayor Bowser, who, by the way, even she did more than her council authorized or than she thought to ask them to authorize. If you're not in that fortunate position, you're like most governors, which is you are improvising and you're claiming you just have some background power as governor to do good. I think it is inevitable that some of what they are doing is going to raise possible constitutional issues. Among other things, you're closing down places of worship. You're making it difficult for people to assemble, to petition the government for redress of grievances. You are, in effect, taking property without due process. There are a lot of different constitutional issues that are raised by this. On the whole, governors have just marched forward. I'm not criticizing them, I'm just saying that's the situation. It's notable that other countries that we think of as sort of our counterparts, Canada, Britain, especially France, Germany, Italy, Spain, they have enacted legislation authorizing the government to issue emergency decrees. And they have done this partly to control it. So they say you can do this, but it will only take effect for, and the formulas vary, but 10 days, 30 days, 60 days, and then you have to get parliamentary approval. They put various restrictions like that on it. Even the European Convention of Human Rights, which is supposed to lay down these fundamental guarantees as a provision in times of emergency, you can derogate from most of them. You can say they're suspended because there's a threat to public order or health or safety or something. America, by contrast, is just winging it. Now we're starting to have lawsuits. We had last week the Supreme Court of Wisconsin by 4-3, but still the majority said no. The Secretary of Health Services did not have the authority to issue this total lockdown order. And so the legislature is going to have to authorize this, or it's not going to happen. At the very least, if there's going to be an executive order, there needs to be a lot more procedure before they do it. Suits like this in a whole bunch of states. My prediction is courts are going to duck, they're going to mumble, and when it's all over, we'll not know a lot more than we know now about what the sort of reserve power of government is to deal with this kind of crisis. Since I mentioned European countries, just to remind you, most European states derive their legal systems, at least the private law provisions, from Roman law. So it's worth saying a little bit about what the Romans did. The Romans did something very notable. They had this office to deal with crisis. They called it the dictator. It's literally dictator. And it was a standard practice between 500 BCE and about 200 BCE. So over 3 centuries, they did this 82 times. So almost every generation of Romans had some time under a dictator, and some generations more than once. And the dictator was basically authorized to do whatever you need to do to deal with the crisis. There were two important restrictions on it because they thought of it as a constitutional office. Let me mention first, there was an informal condition, which was almost always the person appointed dictator was somebody who had previously been a consul, had previously served in the highest office, so at which you were elected to. So that showed that it was somebody who had merited trust and had experience. But then there were two restrictions on this. You served only until the crisis was over or for 60 days, not longer than 60 days. So they wanted this to be very restrictive. I'm not saying this as a sneer or a protest, but just like remind you, we've now been having a lockdown that's going on longer than that, or will soon be going longer than that. 60 days is not a real long time. They said unlimited power, but it's not for more than 60 days. And second, you couldn't make any permanent changes in the law. You could do a lot of harsh things. Very often this was to deal with a military threat. So you were like mobilizing troops, you were forcing people to turn out, you were forcing people to follow orders, you could punish people with death for not obeying. But then when it was over, it was over. Sometimes it was to make sure that elections could be conducted in an orderly way. When they had the elections, the dictator had to recede. There are things to be said for that. The Romans themselves got a little bit nervous, and so they stopped authorizing this once they had basically defeated anyone who they could think of after they had defeated Carthage, and they really couldn't, they didn't feel that there would be foreign armies threatening Italy. But once they had defeated all their foreign enemies, there were a lot of tensions at home. They had a series of basically civil wars, and one of the successful generals, Sulla, had himself in 80 BCE appointed dictator without term. And he made a lot of changes in how Rome would be governed. He made constitutional changes. He did actually, after 2 years, say, I've done what I set out to do, and now I'll go back to private life. He didn't actually go back to private life, but he stopped being a dictator. That turned out to be a really, really dangerous precedent. A few decades later, Julius Caesar, another successful general, said, I want to be appointed dictator for life. And since he showed up in Rome with an army, they said, okay, yes, oh, okay. And he was assassinated by senators who said, you're basically setting yourself up to be a king. And we don't want kings in our republic. His successors learned that lesson. They didn't call themselves dictator, but in fact, they ruled unopposed for centuries after that. So you risk something by agreeing to emergency powers, especially if you agree to emergency powers without a time limit. So I want to say a little bit about Jewish law. I'm sure there are people listening to this, starting with Rabbi Schaffner, who could correct anything I say that's too precise or emphatic, but let me just gesture at this, let me just weave at this, because I think a few general tendencies are worth noticing. So there is a category which Hora'at Sha'ah, so which is sometimes translated as emergency powers, but is suspending halachic requirements to deal with particular circumstances. And as the rabbi said at the beginning, there are lots of things online. And to my surprise, when I started, let's see what's there, there's a whole bunch of people advocating, opposing, denouncing, defending applications of this to contemporary debates. Now, I'm not speaking about the pandemic or anything like that, but just can women participate be counted in the minyan, other kinds of leniencies, and maybe if you really need to in special circumstances, this doctrine of the emergency, right? So some people are advocating this, many other people are resisting this. I'm not the person to wade into the middle of that and pronounce. What I want to call to is way before these kind of debates, if you go back to antiquity, there were people doing more shocking things than just counting women in the minyan. They were actually doing executions and not according to the established procedure. And this is discussed in Tractate Sanhedrin, where they explained to you how difficult it was for the Sanhedrin to hand down a capital sentence. It was so difficult that it hardly ever happened. But then it turns out there were executions in the name of something that were done on the side. There's an episode that's described there, Shimeon ben Shattach, who executed 80 witches in Ashkelon. It seems like in 1 day or 2 days. Was that lawful? Well, he didn't go through procedures. He didn't have the approval of the Sanhedrin. He just did this. And it seems that some people at least thought that it was an emergency. It's interesting to think about, like, what's exactly what's going to happen if you don't immediately execute them? But this is discussed and not simply repudiated. There are a few other examples of things like this. I think the most telling thing is there seems to be acknowledgement that the king has authority to, let's say, impose order, among other things, to punish disobedience to his orders, if necessary, with execution. And that seems to have been accepted as, oh yes, you need that on the side. There's a famous passage in Sanhedrin: the king neither judges nor is he subject to judgment, meaning he can't participate in deliberations of the Sanhedrin, but they can't tell him what to do. And they tell a little anecdote about one of the Hashmonayim who shows up, and it was not good to have him show up. And they didn't want to listen to him, but he didn't want to listen to them. And so then going forward, you have this doctrine, the king is out there on his own, on the side. Michael Walzer was very interested in this. He wrote this little essay, and he said, this is a story of a failure to incorporate kingship within a constitutional structure. I guess that's a way of putting it. But I think what it's really telling you is the Sanhedrin was prepared to acknowledge that sometimes you might need to have the exercise of force outside of halacha. And I'm no scholar of this, but just sort of browsing, one of the things that's kind of interesting, and a lot of commentators do find it notable, when the Rambam has a whole treatise about kingship, and he endorses this idea. You need to have royal authority, and he seems to envision it as something which is sort of parallel to, on the side, and for purposes other than upholding halacha, on the grounds that every community needs to have some background enforcer of basic order, because it's intolerable to have chaos, like out of control crime or rebellion. The point that I mentioned this just to emphasize is there seems to have been this, over many, many centuries, this idea among not just Jewish thinkers, I don't know what that category means, but jurists, people really focused on law, that of course halacha, but then there's this thing on the side, to call it emergency power, but actually some other special power which you need to have. And I can't say this with any confidence, but just my sense of this is the reason they were somewhat comfortable with that was they did not want to stretch or reshape or dilute what they considered to be halacha. So they preferred to say, okay, this is something else on the side. That's not the halacha. The actual halacha is something else. There might be rabbinic ordinances that you add to it, but under very specified conditions and never in conflict with it. So I want to say, we have trouble doing that in America with our civil law. I think it's not because we don't care about law. I mean, as a society, I think we care a lot about law. But to quote Shakespeare, you could say, we love the law, not wisely, but too well. So I want to give, I'll finish in just a few minutes, but I just want to give a few famous examples of how uncomfortable our Supreme Court has been in working this out, to deal with the extreme case, with the emergency, with the crisis. And I think whatever you do, it's awkward. Let me start with the one that's quoted all the time as we do not make exceptions, the law is the law. This is this case that arose right after the Civil War in 1866. Ex parte Milligan. Milligan had been, he was in Indiana. He was opposed to the Union war effort. He was denouncing the draft. He was giving aid to Confederate conspirators. And anyway, the army picked him up and they conducted a military trial and they sentenced him to death. And before he could be executed, he appealed to the Supreme Court and they said, oh yes, we will grant habeas corpus and we insist that you cannot be executed by military court-martial if regular courts are available, which they were in Indiana. And they have this famous statement: the Constitution of the United States is a law for rulers and people, equally in war and in peace. It covers with a shield of its protection all classes of men at all times and under all circumstances. No doctrine involving more pernicious consequences was ever invented by the wit of man, than that any of the Constitution's provisions can be suspended during any of the great exigencies of government. Such a doctrine leads directly to anarchy or despotism. So that was great. And everyone likes to quote that for the proposition that the Constitution, always the Constitution, nothing less than the Constitution. But really they were blustering, because for the previous 4 years, a whole bunch of people had been tried in states that had courts available with the approval of courts. They tried to get rid of habeas corpus, and court said, no, sorry, that's been suspended. You're just left to military trials. This is not even acknowledged in the Supreme Court opinion. And I think it's not acknowledged not because they didn't know about it. They surely knew very well about it. It was just too complicated to explain. Like, well, actually, this was okay during the war, or actually during the war, we did lawless things, but now it's peace, so we repudiate. They just like, let's say something edifying and inspirational and cover that over. In the 1930s, there was a big crisis, not from war or rebellion, but the Depression, of course. One of the things that happened was people couldn't pay their bills, in particular farmers who had mortgages couldn't pay the banks, so the banks would come and foreclose. And there were in various states people with guns saying, when the sheriff comes, we would just, you get together with your neighbors with guns and say, you will not auction off this farm, and anyone who bids on it, we will shoot. So a number of states tried to deal with this. One of them, Minnesota, said, no one has to pay right away. They had this deferral. This is something we're very familiar with. We're having this now. And the Supreme Court, when this got to them in 1934, they give the same kind of speech. Emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power, whether granted or reserved. The Constitution was adopted in a period of grave emergency. And then they say, while emergency does not create power, emergency may furnish the occasion for the exercise of power. In other words, there might be things that you can do under the Constitution in a time of emergency, which you couldn't do otherwise. And if you find that a little confusing, everyone else did too. And what followed from that was it was very hard to enforce the guarantee in the Constitution against state laws impairing the obligation of contracts, because people said, oh, wait, as they said there in that case, I mean, if the state legislature thinks there's a good reason to relax the obligation to pay back on time, well, then that must be okay because they said it was okay. We kind of lost any sense that this was something connected with an extreme emergency. We just came to accept the idea that the prohibition against impairing the obligation of contracts is something actually kind of flexible. That was a 5-4 decision at the time. It was not obviously correct. The dissenters say, well, what are you talking about? You've just now removed something from the Constitution. But it happened, and a lot of subsequent cases cite it with approval. Let me give one more example, and then I'll wrap up. So we had this challenge after 9/11, a whole bunch of people threatening us. We have troops in various places, and the people we're fighting are not regular soldiers in uniform that are under the military discipline of a regular force. So we, at the beginning, captured all these people in Afghanistan, and then later various people were handed off to us as terrorists, irregular fighters. We sent them to Guantanamo so they wouldn't be in the United States. They said, no, you're holding us without trial. So they sought a writ of habeas corpus. And then the first big Guantanamo case, it's called Hamdan versus Rumsfeld in 2004. The majority of the Supreme Court says, oh, you can't deny habeas corpus to these people because you could be holding them indefinitely. But on the other hand, you do need to hold them. So we're going to say you cannot suspend the writ of habeas corpus, or you can't disregard it, but it doesn't mean what people for centuries thought it meant, which is the guarantee of trial and due process in the ordinary courts in the ordinary way. And instead, the court comes up with this compromise, which is, well, the government can hold these people indefinitely, but it has to have some kind of military process to sort out whether they really are unlawful combatants or people who just got there by accident. That's probably a good idea. Maybe it's a good idea. No one ever thought that's what the guarantee of habeas corpus meant, and I mention it because Justice Scalia and also Justice Stevens said, wait, you've extended the protection of habeas corpus by totally changing what habeas corpus means. So you're improvising a new protection, which is simultaneously weakening the protection people thought they had in the United States. I don't know where that's going, but it illustrates the, we sometimes try to stretch the law to cover awkward cases. And in doing that, you really undermine what otherwise might have been something that's like, no, the law is clearly this. As I said, I don't really know where this goes. I want to just close by mentioning to you in the Wisconsin case last week, there was a 4-3 decision. Unfortunately, it was Republican appointees against Democratic appointees. The Republicans had the majority. The dissenters emphasized the obvious point. It's really, really urgent and important to have health safeguards at a time like this. And so, of course, the law should accommodate this, and you should not fuss over technical questions about procedure, to which the 4 majority justices say, these are not just technical questions about exactly what authority was given to the health department to issue rules and what procedure they have to go to. In the background is something we should care a lot about, which is the constitutional rights of people in Wisconsin. There's a presumption of liberty, there are property rights, there are a lot of concerns there, which we shouldn't allow to be just completely disregarded because a health official thinks, no, the better thing is this. I think that's hard, that is difficult. And you see where it goes if you are too quick to say, go with health, you should always go with health. There was a dispute in California, which also got a decision last week. It's called Gish versus Newsom. It's just a district judge in Southern California. The issue there was people who wanted to have church services, and they said, we are willing to space ourselves apart. We're willing to do it outside. We're willing to do it with a lot of safeguards, but it's just not right that you have a total ban on this. When you're allowing a lot of other things to go on, and this is really important for us. You're allowing supermarkets to be open. People need food. We think we really need to attend the church. It's really important. We ought to be able to have this in some version. And the judge said, during an emergency, traditional constitutional analysis does not apply. He didn't have time to work on this opinion. It's not a master of legal, masterful legal analysis, but he's already thinking like, we don't have to worry that much about really the Constitution because the magic word emergency has been said, and therefore this is all lawful. You lose something if you are too quick to let the law accommodate and you have no framework for it, like not more than 60 days or under these conditions, right? You're losing something. Justice Jackson himself, famously in the Korematsu case in 1943, this is, can the government force Japanese Americans on the West Coast into detention camps away from the coast? And the majority of the court said, well, it's an emergency, it's war, the president has war powers, yes, yes. And Justice Jackson said, which I think is very attractive, I'm not saying it's right, but you see the force of it. He said, in an emergency, the military is going to do what it does. I'm not saying we should halt the military, but we shouldn't endorse it. We shouldn't say it's right. We shouldn't create a precedent. And I'm afraid we are in that situation now of we're getting courts to endorse things which they, for understandable reasons, are afraid to say no to, but you are in danger of building up precedents saying nothing else is really important except health, which I don't think that could be true, among other reasons, because health doesn't just point in one direction. There are a whole lot of different concerns which could be described as health. So for myself, I want to say I went and looked at I wanted to see the wording of it, the notice that we put on the entrance there at Kesher, which gives a halachic rationale for why we are closing down. And I had noticed, because I live right near there, I walked by St. Paul's Episcopal Church, and they also put up this sign saying, the Episcopal Bishop of Washington has ordered us to close in the interests of the health of our members and the community. And then they say, this is consistent with DC law. But they didn't say, we're slaves to it. And if DC said it, that's it, which I think is particularly impressive for the Episcopal Church. So good for them. I mean, yes, the government needs to respond to an emergency. We should all be kind of cautious. And if it is an emergency, to try and keep it in a box out there, like the special powers of the monarch. That's a particularly good way of thinking about it because we don't have a monarchy. I didn't mean that as a joke. I mean, it is up to us to fashion how emergency powers will be used, at least to some extent. And we should be a little nervous about letting ourselves fall into a situation in which we think everything that is well-intended is lawful. Anyway, that's what I wanted to say, and I'm glad to be corrected or challenged or extended if someone wants to add to what I said. Thank you.
Thank you. Thank you, Professor Rabkin. We have some time. Happy to open it up to questions if people have. I think there might be a way to raise your hand, but, oh, okay, there is. Let's see, Danny Satlow's got his hand raised. There should be a button for people to do that. So go ahead and unmute yourself and feel free to ask. And then Michael.
Hello. So first I just want to say how great it is to see everyone. It's always great to be a part of this wonderful community. When I think of state of emergency, I often think of stuff that I read in undergrad dealing with Carl Schmitt.
Yeah.
And the state of the exception.
Yeah.
And I'm wondering, so to kind of summarize Carl Schmitt on one foot, which is very difficult. I think he says that the underlying kind of that liberalism as in kind of our faith in law and our faith in democracy and parliamentary measures are things that are that do not properly address the core roots of human nature, right? And that for him, right, what he sees it much more as in a much more convincing way, the development of law comes from the sovereign who declares the state of exception, and then from the exception, then kind of laws come forth as a way to show kind of right, how laws and societies develop rather than from kind of building up norms. And I'm wondering how much you think Schmitt's critiques play out today among the Constitution in the time of COVID-19.
Yes, thank you for raising that. A lot of people are fascinated by Carl Schmitt. I mean, maybe repelled, but still fascinated. So just if the rest of you are not following who this guy was, he was a legal scholar in Germany and wrote very interesting and influential works during the 1920s. And then he decided to become a Nazi, and we arrested him at the end of the war and couldn't quite figure out exactly what he did, although he was a bad influence, and he was not prosecuted, but he was, denounced. I think he's kind of weirdly legalistic for somebody who wants to talk all the time about emergency and the exceptions to law. He has this famous saying, sovereign is he who determines the exception to the law. Everyone's bound by the law, but then there's this one point of authority, and he's thinking of, either the president during the Weimar Republic or the Führer afterwards. He's not bound by the law because he can respond to the exception. And the logic of that seems to be everybody will fall back and say, oh, you have declared an exception, so it is an exception, so we go along with you. And unless you are prepared to unleash mass terror, a lot of people won't go along with it. I mean, this is where we are right now in America. I mean, all these governors are saying, all right, everyone has to stay indoors. You absolutely have to stay indoors, and you can't do this and you can't do that. And people are disobeying this. And we're having a kind of test of will. Are you prepared to put these people in jail? And you probably saw this. Governor Abbott had to rewrite his proclamation to say, oh, no, I didn't mean jail term, sorry. Although, I don't know, if you give an order, doesn't it mean jail? This was a big issue in Wisconsin. The justices there who were against the Secretary of Health order said, wait, you're backing this up with criminal sanctions. So this is a real serious thing. We don't normally think that criminal law can be made by an administrator in this way. But apart from anyone's analysis of the law, Carl Schmitt or the Wisconsin Supreme Court or their dissenters or anyone else, it's really hard to put over something really extreme if most of the public doesn't accept it. And if you are a constitutional executive, and I'm not saying constitutional in any high-flown way, but just you do not have the Gestapo to back you up. If there's a lot of public resistance, you're in trouble. And it's bad for you if people start to think, whoa, you're crazy and we don't trust you anymore. So I think there are quite a lot of constraints on, in real life, our executives. So I am not saying, oh, as Carl Schmitt said, they can impose anything because they have the authority. No, they can't. That I think that's just fantastical. But you would not like people to lose one by one their internal sense of what the boundaries of acceptable government are. And you might relax them in an emergency, but you want people to hold in their heads, okay, just for the emergency, because this is a special case. Anyway, that's the best I can do. But if you want to pursue this, come after me on email.
Okay.
I'll dredge. I've actually written something about Carl Schmitt, which I'll be glad to send you.
Great. Michael.
Well, thanks very much, Professor. I want to go back briefly to your Civil War example and the way in which courts sometimes create a fictional history to get to the right outcome, because everything sort of seems to need to fit together in terms of the opinion. I wonder how much that's the proper role of the judiciary to get to the desired outcome and build the history, versus the judiciary sometimes to simply say, this is what the law demands of us, we can go no further. but these circumstances are exceptional, and we could understand we're an executive to see an exception here and act accordingly. But for example, if the Wisconsin Supreme Court had said the law is unambiguous on this, or the preferred minority position here, the law is unambiguous, and yet, where do the judges fit in, and how should the judges be framing their opinions? Thanks.
Yes, so we don't have time for me to share my whole philosophy of law, which is good because I don't really have a very well-developed philosophy of law. This is a challenge. This is a problem. I think if you are talking about, which this happens all the time, what did the Second Amendment guarantee mean in the 18th century, or better, what did it mean in 17th century England? That is so remote that, I mean, different judges have their own history and it's pretty remote. So it's somewhat a matter of taste, which you find helpful for making your argument. But if you're talking about something as kind of basic as, what do we do when there's a rebellion and there's a war going on? I think it doesn't do to just pretend that big things that happened didn't happen, so never mind, and no one will remember. First of all, they will remember, and second of all, the thing that tempted them to do it, but they weren't just tempted. I mean, the Congress authorized this on a number of occasions. President Lincoln did it repeatedly. It didn't just happen just like briefly on the side. This was an important part of the war strategy of the Union. I will break for this inspiring anecdote, as it seems to me, which is there's a famous painting of President Lincoln signing the Emancipation Proclamation, and the whole cabinet gathered around him. Very famous painting. And the artist who did it, he actually spent a lot of time in the White House sketching all the different people so that he could make this an authentic picture, at least get the faces right. And so they had a big public showing and people waited online to see it. And Secretary Seward said, you know, they're all carrying on like the Emancipation Proclamation was the decisive thing. They should have a picture of President Lincoln signing the order suspending habeas corpus. That was much more courageous and that was much more decisive. I'm not saying he was right about that. I think he wasn't right about that, but he wasn't just being sarcastic. It was quite a big thing that was done in public. So I'm not sure that you really are able to restrain it by saying, oh, let's just pretend it didn't happen. The same kind of thing that impelled Lincoln to do it is likely to impel a successor in similar circumstances. And you don't have a good answer to say, I'm putting my hands over my eyes and not seeing it, so it's not happening. So I don't think that's the best way of dealing with it. It maybe would have been better to say, we need to have more boundaries of like when, how, maybe Congress should be pushed to enact a more general scheme for this, maybe. But we don't like doing that in America because we don't like acknowledging that, oh yeah, there will be emergencies in which we'll have to kind of bend, and we don't like to acknowledge that we're doing that. I'll give you another, just to show that there's a reason why we get caught in this. Another great line of Justice Jackson, who said in the steel seizure case in 1952, President Truman can't seize the steel mills just because it's convenient for him to deal with war mobilization. And he said, the framers must have suspected that emergency powers would tend to kindle emergencies. That's a very good line. If you acknowledge that, oh yes, there's emergency powers, then people can be finding emergencies all the time. I mean, executives will, because you've already told them. You just have to say the magic word emergency. So that's a problem, which I don't have a real good answer to, although I think we would be, I think, somewhat better off if we were somewhat more adult about this and not pretend that the law covers everything and don't worry, you can all go back to sleep. Hand-wringing is not the answer to everything, but it's a good start, yes.
David.
Hey, Jeremy. I guess my question is predicated on the assumption, which I don't think is any kind of partisan political statement, that to a large extent, the federal government is maybe abdicating to the states more than you might have expected in a national emergency. And if that's the case, I'm wondering what your thoughts are on whether that's going to muddy the waters in terms of the case law that emerges to decide all these legal issues. Because if you had a federal law that was being challenged in federal courts throughout the country, you'd have the same law being challenged, probably a similar fact pattern. And even if the circuits split on the result, that would increase the chance of the Supreme Court taking the case. And even if it didn't, there's still a limited number of circuits. Whereas in the state environment, there's 50 state legislatures and jurisdictions within those states even doing a bunch of different things, different courts. So you've got different fact patterns being decided by different courts that, yeah, could go to the Supreme Court, but probably less likely given just the diversity of different laws being decided. So I'm wondering whether you think, first of all, to the extent that there's much of a sample size, whether this crisis is unusual for the amount of authority being sort of abdicated to the state and local level, and if so, whether you think the case law will be sort of all over the map as a result.
So I should start by acknowledging I'm somewhat partial to federalism because I just think it's a huge country and it's better for us to have different responses in different places. But apart from that, I think you're not right when you say, oh, the federal government abdicated. The federal government had no really relevant authority to order lockdowns. I just don't see that. And I think there's a reason why Trump didn't actually issue an order that was now everyone will lock down in place. He was, I'm not really saying this as a like, how dare he? I mean, this is what he does. He was burbling, he was just like talking. He didn't have the authority either to impose the lockdowns or afterwards to say, all right, now we can come out of them. There's no legislation that is close to that now. The states didn't really have legislation for this either. And that is a thing that it's just good for us to remember this, which is we didn't do this in 1918. And so far as I know, we just have never done this. I mean, cities have done this, but in some episodes. But on a large scale, across a whole state, I don't think that's ever happened. I'm not sure. I mean, I didn't look at what 50 states say, but just from reading a little bit of research, definitely Maryland didn't authorize this. Definitely DC didn't authorize this until this spring. Definitely Wisconsin didn't authorize this. And I don't think other states had either because they just weren't envisioning this. I think it probably was sensible, but again, that's maybe just my bias in this, to think state by state, they should figure out what to do. Among other things, it's even in New York where the governor has been, very active, he's acknowledged, okay, New York City and Buffalo are in a different situation than most of what's in between, where there's just not that kind of population density. And, one of the things that makes the total lockdown acceptable to the extent that it is acceptable in New York is there's a lot of services. Like people can deliver things to your apartment or anyway to your building, which I lived for a long time in Ithaca, New York. I don't believe there was any, I've never heard of it. They could deliver something to your house. It just wasn't set up like that. It would have been much more of a costly thing to do. Maybe I suppose you could hire Ubers and stuff, but it would be quite an undertaking to get around a total lockdown. So it just doesn't seem to me right that we should have been thinking about this as the same standard across the country. And whatever we decided to do, wherever we decided to do, there were going to be issues about it. And if you are saying, if I understood you rightly, oh, don't worry, different courts could deal with different fact patterns. Really? Why is it an advantage why would it be advantageous to have a national standard if different courts in different places are going to apply it differently or interpret it differently? I just think this was going to be messy one way or another, and I don't think it would have been worthwhile to say, let's start with total federal authority and then spend time arguing about it in 50 different jurisdictions, although in fact it would be, whatever it is, 100 and something, almost 200 different jurisdictions, given how many district courts there are. Can we do one more?
Yeah, anybody else want to ask another? There aren't any more hands up.
So Mr. Laval, Gerard Laval, threatened that he was going to attend, as he said.
Well, Jeremy, thank you for your presentation. If I may, I'd just like to ask one question. The big issue here is, what's an emergency? How do you determine the existence of an emergency? It's one thing when Franklin Roosevelt declares war.
Right.
Yeah, that's one thing. It's another thing, for example, I suppose if in a very limited space, there's been an explosion, there's a volcanic explosion, whatever. But how do you determine here, on what basis, and how would courts, or for that matter, governors or mayors, realistically determine that there's really an emergency?
Yeah, so I want to say two things in response, and one is what was good about the Roman way was the Senate had to say, this is an emergency, now we're having a dictator. So there was some kind of political decision. There was a political trigger on this to start with. And the European schemes are, you proclaim an emergency, but then you have boundaries within which you operate. We have no real trigger nor any boundary on the other side. So that makes it all kind of squishier and messier. And I think that is a problem. I also think when you look at state codes, they were envisioning things that were like a matter of a day or two. Everything is underwater for how many days? Not many, right? The power is out. For how many days? Not many. There's a riot. Okay, how long does that go on, right? They were thinking of things that would be quelled within a few days. And I think they just didn't, I think no state really provided for something that would go on for months. I'm not saying that shows that we shouldn't do anything. I'm not saying it isn't an emergency. I'm just saying it's like, it's hard to deal with.
Can I just ask one sort of a follow-up? But since we're a religious institution as a group, what do you think is going to be the balancing between these orders to shut down religious institutions and the First Amendment, which obviously guarantees to some extent the right to worship as we see fit? That's going to be a big, it's clearly going to come.
That is a very serious problem. I think that is a very serious problem. I do want to mention, just like why we came to this, I saw that at the beginning of the crisis in Israel, so back in March, Rabbi Lau, the Ashkenazi chief rabbi, and Rabbi Yosef, the Sephardic chief rabbi, they made a joint statement saying more or less what Kesher has said. There's an obligation to not to spread disease, not to do anything that will risk health, your own or that of others. So we're calling people, don't go to the kotel. And even though it's a mitzvah to visit the sick, don't do it. And it's a mitzvah to visit the old, don't do it. Right? And they made a pretty emphatic statement. And again, as with our statement, I thought it was interesting. They did not say, Dina de Malchut Din. I mean, they didn't say, obey the government. They said, we're on parallel tracks with the government. Now, what happens if, you know, it's the Satmar community and they say, feh, you know, we don't go along with that. We think you should go to the funeral. I mean, it's a real problem. Mayor de Blasio was not wrong when he said, this is not just about endangering yourselves, it's potentially endangering other people. So it is a real problem. I think it is a real problem. I think it is fair, at least, to ask that courts don't just, you know, kind of run along without giving it a second thought that, oh, it's an emergency, oh, it's health, so there's nothing to think about. I mean, at the very least, you might want to make sure, which is what they were arguing in California, that your whatever benefits you're giving to some other essential services, you at least consider that maybe religious institutions would qualify or qualify under certain limiting conditions if they do social distancing and so on. But I don't think that should be just like swept off the table, because I think it is a real challenge. And it's one of the things that would allow us to maintain some boundaries on emergency powers, right? That remind people that emergency doesn't mean everything goes by the boards.
I mean, there are times when government steps in and limits, you know, religious practice because of health concerns.
Of course.
Whether it's female circumcision, whatever it is.
Of course. Yes, and I am not saying the Constitution means there can never be limits on religious practice. I'm not saying that. But at the very least, you should be cautious about that. I mean, we do have a federal statute which says things that are done by the federal government, if they restrict religious practice, the federal government must show a compelling need. It's not enough to say, well, it seems like a good idea. That could go for a lot of other things, but not if you're restricting religious practice. So that's sensible law, I think. And maybe you want to have in mind something similar to that under the First Amendment when you're dealing with the states. I mean, this is not yes or no, on or off, all or nothing, but there ought to be some special consideration given for religious institutions, because we, precisely in a time of emergency, we're basically saying, okay, a lot of other things are going by the boards. To give one example that I think is not frivolous and might affect some members of our congregation one way or the other. So a lot of states and DC are saying, if you can't pay the rent, that's okay, it's an emergency. Now, of course, I'm a little sympathetic to that. I understand that. There are people who suddenly don't have any income, so they really do have trouble paying their rent. On the other hand, there's something a little unfair about saying to the landlord, hey, you can go without income, so it's okay, never mind what the contract was, because, I mean, maybe some landlords, maybe Jared Kushner can afford to shrug off rent payments in his properties, but there are a lot of landlords who are, they own one building and they live upstairs, and it's actually kind of important for them to have the income. They were counting on the income, right? They're retired, and this is really important for them to have the income. And if you just say, oh, never mind, they don't have to pay, you've really taken something really important from people like that. So I'm not leading up to, let's go back to the contract clause the way it was in the good old days. I'm just saying we are prepared to shrug off a whole lot of other things that have some claim on our sympathies. But I really do think religious institutions should be in a different situation where judges ought to have the confidence to say, now come on, wait, whoa, I mean, do you really need to do this? And if you really need to do this, okay, I mean, maybe temporarily, yes, but you should make some showing that it's really urgent. And you should at least give them a chance to explain why what they are proposing to do will itself be very limited and relatively unthreatening. I don't think there's that many institutions actually. I mean, maybe I'm being optimistic and naive about this, but just thinking about Washington, I don't actually think there are that many religious institutions that would want to fight this. I'm not sure how well we would do this, because we have a lot of people who might like to attend, and we have a relatively small space. But we might think about, this is not leading up to let's go out and do this, but I mean, we or some other institution might think about doing things that were relatively cautious and modest, in the sense of not involving a lot of people who could then be spaced out. I mean, it seems to me people are pretty well spaced when they come to Shachrit. Right, and we could just say, we're going to let the first 11 people show up, and they're going to space themselves out, and not more than that.
Finish davening at 9:45, then it'll be.
No, you have to do it, of course, at 7:30 or whatever, 7:15. Sorry, yes. But I'm just saying. I mean, I think this is not all or nothing, and maybe we should be thinking about situations in which courts could ask, are there somewhat safer alternatives that could be considered? And if you want to fight for that, maybe you can fight for it. And if you think, no, we don't want to take any risks, okay, also okay. I think it would probably be a while before we have a kiddush with everyone packed in together like that.
Yep. Yeah, I will say that we have brought a group together already this past week to start talking about what happens when the government opens up, and religious institutions agree that they're going to open. Should we start ordering masks now and cleaning supplies, and how do we do that? And it's complicated, and what do we do for high holidays?
Complicated. It is very complicated, yeah. But it's good to be complicated, right? Because that shows that you've moved beyond all or nothing.
Mhm.
And complicated is in a way a tribute to like we're trying to accommodate. We're trying to think our way through it, and I think that's better than saying it's an emergency and we all swoon.
All right, Shkach, I want to say a big thank you to Professor Rabkin, and just remind everybody there's a lot going on Zoom at Kesher. Wednesday nights there is Pirkei Avot being taught by different people in the congregation. I teach a little bit each night. I'm going to teach something before Shavuot, and the next two Voices of Kesher events will be, the next one will be next Sunday night at 8, and it'll be Professor Charles Manikin, who, if you don't know him, he davens at Hashkama every Shabbos when we're open. He's a professor of the Rambam, and he's going to speak on ghostwriter, translator, or secretary, the Rambam on Moses' role in transmitting Torah. That'll be next Sunday night at 8. And I want to wish everybody a wonderful week, and we should all be together healthy and soon.
Thank you very much.
Thanks.
Thank you.
Amen.
Thank you.
Great to see everybody.